It claims that, as a consequence, the trial chamber erroneously focused on Sefer Halilović's role as commander of Operation Neretva and on his control of combat operations to determine his effective control over the offending troops. The appeals chamber has considered carefully the way the prosecution pleaded its case at trial and the fact that a trial fact is necessarily bound by the theories of the case advanced by the prosecution. It concluded that the prosecution clearly pleaded that Sefer Halilović exercised effective control by virtue of his command of Operation Neretva. The appeals chamber has therefore dismissed the prosecution's allegation that the trial chamber erred in failing to consider whether Sefer Halilović had effective control over the perpetrators of the crime by reason of his position as team leader of the inspection team or by virtue of his position as the most senior ranking officer in Herzegovina at the time. As a result, the appeals chamber limited its analysis to the prosecution's submissions regarding Sefer Halilović's effective control as commander of Operation Neretva. In so doing, the appeals chamber focused its assessment specifically on the allegation that he was a de facto commander, since the prosecution acknowledged that it failed to prove de jure command. The appeals chamber notes that the trial chamber correctly set out the elements that must be satisfied to hold a superior responsible under Article 7.3 of the statute. However, the appeals chamber has found that the trial chamber erred when it appeared to create a new requirement to the third element of superior responsibility. That is, failure to take the necessary and reasonable measures to prevent the criminal act or punish the perpetrators thereof, by unhelpfully adding an artificial distinction between general and specific obligations to prevent crimes. In any event, for the reasons I will discuss, this particular error does not have an impact on Sefer Halilović's acquittal.
Under subground 5, the prosecution submits that the trial chamber erred in misapplying the standard of proof throughout the judgment. Under subground 2 and 3, the prosecution raises two specific allegations of errors related to the same alleged mistake. First, the appeals chamber considered that the prosecution misinterpreted the holding by the trial chamber that any ambiguity or doubt was to be resolved in favor of the accused. The trial chamber, in this case, simply reworded the beyond reasonable doubt standard in a manner consistent with the jurisprudence of the tribunal. The prosecution also alleges that the trial chamber erroneously applied the beyond reasonable doubt standard to all exhibits and findings, and not only to the ultimate issue of Sefer Halilović's guilt. While not every factual finding must be established beyond reasonable doubt, every fact which is indispensable for a conviction must be. Our case law has made it clear that apart from the elements of the crime and the requirements for criminal responsibility of the accused, there may be other facts indispensable for a conviction depending on the specific circumstances of the case and on the way the case was pleaded by the prosecution. In any event, since the prosecution has only identified a handful of findings that were erroneously reached, the appeals chamber has limited itself to consider these. The appeals chamber has, in this respect, found that the trial chamber did not require proof of the name Operation Neretva as a necessary precondition for a finding of effective control. The same can be said of the discussions and decisions taken at a meeting in Zenica in which Halilović is said to have participated. Similarly, despite having found that the trial chamber did err in focusing on whether a formal forward command post has been established in the town of Jablanica, the appeals chamber has concluded that the prosecution failed to substantiate its claim that had the existence of this post been established at trial, the trial chamber would have concluded that Sefer Halilović was de facto commander of the perpetrators of the crimes. The appeals chamber has further considered subground 4 of the first ground of appeal, under which the prosecution submits that the trial chamber erred in concluding that since Sefer Halilović did not initiate or carry forward investigations, he did not have the material ability to punish the perpetrators of the crimes. In this regard, the appeals chamber first considered that the wording used by the trial chamber might be confusing, since the failure to initiate investigations is not as such an indication of a lack of power to investigate. However, the trial chamber did not base its conclusion that Sefer Halilović lacked the material ability to punish solely on the evidence that Sefer Halilović did not initiate investigations. On the contrary, it carefully analyzed the evidence before it, notably the specific rules and the evidence regarding the authority to conduct such criminal investigations, before concluding that Sefer Halilović did not have the material ability to punish the perpetrators of these crimes. The appeals chamber has found that it was not an unreasonable conclusion given the evidence in the record. In any event, even assuming that Sefer Halilović had the ability to contribute to an investigation or to the punishment of the perpetrators of the crimes committed in Grabovica,